Well, you raise an interesting point, Frank. One of the understated things that Charles Ruff is doing is really treating the House managers with a little bit of belittling contempt. He characterizes their argument in words like simplistic, trying to make the senators believe that these House managers are really not worthy of bringing these charges before the United States Senate. That, of course, is a tactic we can expect to continue. It is something that has been done behind the scenes a lot to attack, as a matter of fact, the integrity, to attack the capabilities of the House managers. Of course, they also have to face the fact that the managers were given points by just about everybody involved by the presentation they made last week. But now it's time for the White House to try and say, wait a minute, their points were not really up to the standards to argue that the president should be removed.
It's a very good point, Jeff Greenfield. I remember Max Baucus, the Democrat, coming out at the end of that presentation saying they pushed this uphill, referring to the managers.
And I think exactly the point is that what we're getting here is a reminder to the Senate, please forget the good House managers of the last few days. Remember that bunch of partisans that threw the Judiciary Committee into such a morass, when he particularly, one point, when he went after them for impugning the integrity of the 900 academics and scholars who signed that piece of paper, and he said, do you really think Gary Wills sold his soul, C. Van Woodward sold his soul? In a way, he was saying to the senators, remember that bunch of take no prisoners, scorched earth fire breathers that you didn't like a month ago? Keep that in your picture and get rid of those thoughtful people who gave you that presentation a few days ago.
Candy Crowley, to whom is Ruff addressing himself?
Well, he's addressing himself, I think, really primarily to the group within this chamber. This is not the side that has to make any kind of appeal to the American public. I think you just look at the recent polls. The American public seems pretty much convinced that whatever happened, they don't want this president removed. What Mr. Ruff and others will do is try to keep that solid Democratic majority together. Remember, the first key vote could come as early as next Monday, and what they really want here is to get to that 34 mark, regardless of what the vote is about. They need to have 34 senators that will vote and signal that no matter what happens, there are not the votes there to impeach. So what they're trying to do is to keep the Democrats together, and as Jeff says, remind them of how they felt about these House managers before they came over, try to keep any slippage from the Democratic Party. I think they basically have written off the Republicans, but if they can keep the Democrats in line, they're basically home free on the bottom line.
Roger Cossack, Ruff said at the outset, in the end, we will have demonstrated beyond any reasonable doubt that you should not convict the president on any of these charges. Now, he's started it, but he's got a lot of persuading to do, as Candy Crowley just mentioned. So where does he have to go from a legal point of view if you were on the floor right now?
Well, first of all, I was surprised that he used the phrase beyond a reasonable doubt, because I don't think he has to convince them beyond a reasonable doubt. One of the things we've talked about is that each senator makes up their own mind regarding what the standard of doubt is, and then beyond a reasonable doubt would be the highest standard of doubt. So we've had senators come on our show and say clear and convincing evidence, but I think, which is a lower standard of proof. But I think that what he's going to have to do is take these facts and take them apart one after another and show, look, as the record stands now, as it stands before you now, there is a doubt, and calling witnesses, there's always going to be that implicit thing. Calling witnesses aren't going to do you any good.
Mr. Ruff has also reminded the senators about what some of them said in the late 1980s judicial impeachments, and I think that's important. These senators will remember what burdens of proof they used in those trials. They'll also remember what kind of evidence they demanded. They'll also remember how they felt, and they'll also remember the need that they had in order to have bipartisan consensus for the convictions to occur.
And it's also, I think, underlying this, and it's a really interesting challenge for the president's lawyers. On the one hand, they don't want to sound like they are dismissing what the president did. On the other hand, they know the atmosphere they're arguing. I was just looking at a poll where the public was asked, how do we avoid White House scandals in the future? 38% said elect leaders with high moral values. 56% keep private lives private. So they know they've got the public with them on the idea of saying, look, it's icky, but it doesn't matter. On the other hand, he's in the well of the Senate arguing a serious constitutional issue, and he can't just say, oh, it was just a frolic and detour.
Wolf Blitzer?
One of the major points that Ruff alluded to, which we'll be hearing a lot more about in the next...
All right, Wolf, I'm sorry, I'm going to interrupt you. They're resuming work in the well of the Senate. The Senate Majority Leader now bringing things back down to the floor.
Ruff. The chair recognizes Mr. Counsel Ruff to continue his presentation.
Thank you, Mr. Chief Justice. My first question is, Is it working? Thank you very much. I apologize for the mechanical difficulties earlier. I could go back over the first hour, but I'll move on. I want now to move to an overview of the articles of impeachment themselves. As I said, as I came to the end of the first hour, these articles are constitutionally defective. They are also unsupported by the evidence. As we have noted, both articles are framed in the broadest generalities and composed of multiple different offenses. Nothing contained in the Judiciary Committee's majority report or in the trial brief or in the presentation of the managers can cure the constitutional infirmity that infects these articles. Nonetheless, in framing our defense, they provide the only way through this uncharted landscape. We have divided our substantive response to the articles into three parts. Tomorrow, Mr. Craig will address the charges in Article 1 that the President committed perjury before the grand jury. Second, Ms. Mills will address those parts of Article 2 that charge the President with obstructing justice by causing the concealment of gifts he had given to Ms. Lewinsky, and that he engaged in witness tampering in his conversations with Ms. Curry. And third, Mr. Kendall will address the remaining allegations of obstruction, which will be on Thursday. And then we will close by hearing from Senator Bumpers. Before I move to an overview of the articles and the response you'll hear over the next couple of days, I want to suggest to you an approach to one of the most difficult questions that you face. How does one sitting in judgment on a case like this assess the reliability of what he or she hears and sees? Let me offer one test. Those of you who have practiced on one side or the other in the criminal justice system know that that system places a special responsibility on prosecutors, a burden to be open and candid and forthcoming in argument and, most importantly, in representing the facts, so that when a prosecutor recites the facts, he's not expected to ignore the unfavorable ones. He's expected to be open with judge and jury. Of course, he can make an argument as to why a particular fact is really not so important, but he can neither conceal it nor misrepresent it. And so when you hear a prosecutor or a team of prosecutors misstate a fact or not tell you the whole story, you should wonder why. You should ask yourself whether the misstatement was an inadvertent error or whether it signals some underlying flaw in the prosecution's case, some problem that they're trying to conceal. And what ought to be particularly skeptical when the fact that is concealed or isn't fully revealed is claimed by the prosecutors themselves to be crucial to their case. Now, we all sometimes speak with less than complete care, and we are justly criticized when we make mistakes. If I tell you something inadvertently that proves to be wrong, I expect to be held to account for that. And similarly, we must hold the managers accountable for their mistakes. Last week, for example, you will recall that Mr. Manager Sensenbrenner told you that during my appearance before the Judiciary Committee, in his words, Charles Ruff was asked directly, did the President lie during his sworn grand jury testimony? And Mr. Ruff could have answered that question directly. He did not, and his failure to do so speaks 1,000 words. Now, just to be certain that the record is straight, let me read to you from the transcript of that Judiciary Committee hearing. Representative Sensenbrenner: the oath that witnesses take require them to tell the truth, the whole truth, and nothing but the truth. And I seem to recall that there were a lot of people, myself included, when asked by the press what advice we would give to the president when he went into the grand jury in August, was to tell the truth, the whole truth, and nothing but the truth. Mr. Ruff, indeed, Representative Sensenbrenner, did he tell the truth, the whole truth, and nothing but the truth when he was in the grand jury? Mr. Ruff, he surely did. Now, I'm certain that Mr. Sensenbrenner would not intentionally mislead the Senate, that his error was one of inadvertence, but in any event, now the record is clear. Of considerably more importance than this momentary lapse are the many substantive flaws that we will point out to you in the coming days, sometimes pure errors of fact, sometimes errors of interpretation, sometimes unfounded speculation. My colleagues will deal with many of these flaws at greater length as they discuss the specific charges against the president, but I'll give you a couple of examples as I reach the appropriate points in my overview today, because I want you to have in mind throughout our presentation, and indeed throughout the rest of these proceedings, this one principle. Be wary of the prosecutor who feels it necessary to deceive the court. Let me begin with Article 1. Our system of justice recognizes the difficulties inherent in testifying under oath, and it affords important protections for the witness who may be charged with perjury. And thus the Judiciary Committee's dissatisfaction with the president's answers because they thought they were narrow or even hair-splitting, in some sense, reflects a dissatisfaction with the rules that have been applied for centuries in prosecuting this offense. Perjury requires proof that a defendant knowingly made a false statement about a material fact. The defendant must have had a subjective intent to lie. Testimony that's provided as a result of confusion or mistake or faulty memory or carelessness or misunderstanding is not perjury. The mere fact that the recollections of two witnesses may differ does not mean that one is committing perjury. Common sense and the stringent requirements of the law dictate that more is required. As the Supreme Court has noted, quote, equally honest witnesses may well have differing recollections of the same event. And thus, quote, a conviction for perjury ought not to rest entirely upon an oath against an oath. This is the rationale for the common practice of prosecutors to require significant corroborating evidence before they bring a perjury case. Indeed, the Department of Justice urges that its prosecutors seek independent corroboration, either to witnesses or corroborating evidence of a quality to assure that a guilty verdict is really well-founded. Now, this isn't merely an argument we make because we are advocates for the president. A bipartisan panel of former federal prosecutors, about whom you will hear more, testified that neither they nor any reasonable prosecutor would charge perjury based upon the facts in this case. Tom Sullivan, former U.S. Attorney for the Northern District of Illinois, told the committee that the evidence set out in the Starr report would not be prosecuted as a criminal case by a responsible federal prosecutor. Richard Davis, former colleague of mine in the Watergate Special Prosecution Force, testified that no prosecutor would bring this case of perjury because the president acknowledged to the grand jury the existence of an improper relationship and argued with prosecutors questioning him that his acknowledged conduct was not a sexual relationship as he understood the definition of that term used in the Jones deposition. And that is where you need to begin your focus as you look at the charge that the president perjured himself in the grand jury in August of last year. Any assessment of that testimony must begin with one immutable fact. He admitted that he had, in his words, inappropriate, intimate contact with Monica Lewinsky. No one who was present for that testimony, or has read the transcript, or watched the videotape, could come away believing anything other than that the president and Ms. Lewinsky engaged in sexual conduct.